crypto, the notion that SEC Chairman Gary Gensler is quitting has swept Twitter. John Deaton, an attorney who is in favor of XRP, has responded on the speculations suggesting that a resignation from Gensler is probable. Since late 2020, the SEC has started litigating against Ripple. As we enter the third quarter of 2023, anticipation for the court's decision on this protracted dispute only intensifies. The majority of people expect a favorable verdict for XRP before the end of the third quarter of this year. The question on everyone's mind is, when will the Ripple and XRP lawsuit end? Members of the internet crypto community had a brief conversation about this on Twitter. Let's analyze the many factors that have contributed to the XRP lawsuit's protracted duration. This tweet suggests that both parties have been stalling in order to gain an advantage in the legal battle. The case received a lot of attention, according to one responder, but if it drags on too long, people will lose interest. According to this remark, XRP's value will skyrocket because of its practical applications. So, in their view, XRP investors will see their wealth grow exponentially over time. As a result, the SEC is trying to lengthen the litigation in the hopes of reducing the number of persons who benefit from it. Another comment suggests that the judge in the XRP litigation is waiting for the parties to settle rather than going to trial. At the same time, Ripple is allegedly postponing the litigation in order to bring on additional AUDL, according to the same answer. In the latter scenario, Ripple is able to amass consumers, clients, and users who are willing to purchase XRP at a discount. Mike concludes my remarks in my answer. They also note that they anticipate the XRP case will conclude in the next month or two, bringing us closer to the conclusion of QA 2023. Furthermore, another statement claims the XRP case will not be resolved for another year. However, they don't provide any justification for why they hold this opinion. Instead, another comment suggests why the XRP case may be over in a year. The American judicial system is notoriously sluggish, so it is probable that any holdups are due to that. The XRP and crypto community as a whole is behind Ripple in this protracted legal struggle. The SEC is said to have a paltry 3 chance of victory at best. The recent drop in XRP pricing is consistent with the first explanation. The longer the judgment takes to come down, the more investors lose patience and sell at a discount. Meanwhile, believers are stockpiling XRP, hoping for their time to shine. On July 11th, John Deaton shared details on Judge Annalisa Torres' extraordinarily high rate of compensation for her rulings. Since December, when reply papers were submitted by Ripple and the U.S. SEC, the XRP community has been waiting for Judge Torres' ruling. 7 months have passed, but Ripple isn't Judge Torres' only case. He said that Judge Torres has failed to issue a ruling in the Thor Equities case despite the fact that the reply papers were submitted in December. However, he disclosed that Judge Torres waited 6 months to declare her judgment in the Fitzgerald case and numerous other cases, and 7 months to announce her decision in the Quiller, Ince vs. U.S. case. Since Deaton has put in the same amount of time as her opponent, she thinks she has a good chance of winning this month. David Schwartz, ECTA of Ripple, responded to Deaton that he anticipates a summary judgment verdict by the end of September. Since Judge Torres' ruling has never been delayed for more than 9 months, Deaton says he agrees with Ripple Q David Schwartz. Although Deaton did not look at every instance, he didn't find any that were longer than 9 months, although one was slightly longer than 8 months. John Deaton, an outspoken advocate for Ripple, has predicted that in her future summary ruling, Judge Torres would provide a detailed answer to the topic of whether XRP is a security. Beachy was once sold as an investment contract, Sexy V, shavers, but that particular sale didn't transform BTC into anything other than what it is, a digital commodity, he said. Deaton further said that Judge Torres will address the problem of secondary sales using XRP, which is something many seasoned attorneys would rather avoid. The underlying asset and secondary market transactions are issues that I think Judge Torres has to consider. Was she able to rule without becoming bogged down in the details? She could, of course. However, not addressing these issues would be an even greater act of judicial activism than considering the sexist theory, he said. Deaton used a case concerning the Telegram messaging service from the year 2020 that was heard by Judge Castile to buttress his claim. The SEC's decision to intervene and prevent Telegram's planned distribution of Gram tokens marked the beginning of this legal conflict. After a failed issue ICO for the Telegram Open Network, Judge Castile sided with the cease and ordered Telegram to pay back investors $1.02 billion. Remember that the SEC's position was that Ripple's behavior resembled that of an iShow on an ongoing basis, with each sale of XRP being seen as part of a larger scheme involving securities. Deaton, meanwhile, made it clear that the XRP issue was different from the Telegram case since the latter comprised an initial coin offering, IQ, with written contracts. Deaton said that the XRP ledger, XRP, technology, which underpins XRP, has been in use and freely traded for over 7 years. Unlike the Gram coin, which was restricted to anyone outside of the SEC, XRP was allowed to be owned by anybody until 2019. The dispute between the SEC and Ripple centers on the question of how XRP may be traded on the secondary market. The SEC charged Ripple with providing an unregistered securities, but it did not differentiate between Ripple's direct sales and the secondary market trading of XRP, which led to some misunderstanding. Deaton has speculated that Judge Torres may explore this issue because of an earlier examination in the SEC CVs, El Bri action. Judge Torres' summary judgment ruling might provide clarity on XRP security classification, which could have far-reaching implications for the cryptocurrency sector. Judge Phyllis J. Hamilton of the U.S. District Court for the Northern District of California has ruled in favor of a class of investors in the class action lawsuit Zakhanov. Lawsuit Zakhanov E's, Ripple Labs and C, marking a significant moment for SERP investors. The main claim is that Ripple is breaking the law by not registering XRP as a securities under federal and state regulations. A huge number of XRP buyers can now pursue securities lawsuits against Ripple, XRPU, and CEO Bradley Garlinghouse, according to this verdict. 2 months have passed since the last court date in the XRP investor class action lawsuit against Ripple. Bradley Sostek, the main plaintiff, filed a request to certify a class of all XRP holders worldwide who purchased, still hold, or sold XRP at a loss. Although defense counsel successfully argued for the action to be limited to us investors, despite Ripple's global presence, this order affirms the right of us investors to seek legal recourse. Judge Hamilton acknowledged the dynamic nature of the law as it relates to cryptocurrency. This ruling marks a significant step forward for the lead plaintiff and his legal team, who allege a loss of $118,100 after selling XRP in 2018 due to Ripple's misleading claims regarding the token's security status, as she emphasized the need to allow individual jurisdictions to enforce their need to allow individual jurisdictions to enforce the cryptocurrency regulations. This paves the way for additional XRP investors to join the class action in an effort to recover their purported losses. Defense attorneys for Ripple and Garlinghouse contended that class members' divergent opinions on whether or not XRP is a security would cause friction within the class. This argument was shot down by Judge Hamilton, who said that any issues could be settled using the usual opt-out method. Nick Spear of Sussman Godfrey was pleased with the court's judgment and excited about the next steps in the lawsuit. A representative for Ripple emphasized the significance of letting other nations regulate cryptocurrencies independently, citing the court's rejection of a worldwide class. As an example, the representative also confirmed that the court is prepared to wait for the conclusion of the SEC-CV Ripple case before moving forward.